It seems a lot happened on September 21st. While I was busy making the video about Alex's plea hearing, Dick and Jim were busy filing a new motion and getting a reply. Elsewhere in South Carolina,
when I decided to plead guilty in federal court, I didn't have any assurances of what my sentence would be there or here. I made a conscious decision to have trust in the legal system, one that I betrayed. I betrayed this system, and I am perhaps undeserving of that. I understand how difficult your role in this process is, and I sincerely thank you for the opportunity to address your court and for considering the information presented on my behalf.
The remorseful, ready to take my punishment Cory Fleming decided he didn't accept his punishment after all. He filed an appeal and has chosen new counsel. But what struck me as so funny in both cases, the courts had to ask for corrections because the paperwork was not correctly filed. Both of these cases are attorneys filing on behalf of other attorneys, but can't seem to get a proper filing done. What is even going on here? Let's get started. It's Legal Updates with Cassidy O'Connell. Welcome. So let's start with Dick and Jim's reply, which, as it turns out, is not from Dick and Jim.
Are you planning to file anything?
Tomorrow, we will be filing a response to the Attorney General.
Thank you.
Mr. Barber here has been working on it diligently.
And I apologize because the audio both from the court TV hearing and this press conference are just absolutely atrocious. I tried to raise the volume a little bit, but it's still very mushy. Sounds like it's underwater, so really sorry for that quality. That's out of my control. Those were filmed by court TV and local news stations. So the usually not allowed to speak sunglasses guy, Phil Barber, is in fact the author. It is full of nastiness. Perhaps he's tired of being the quiet one who has to resort to sticking his face in the huddle while Dick performs and passes all the important questions to Jim. When people can't fight with logic and reason, they often resort to nastiness and name-calling, which we've seen happen in action with Dick, especially in court. I'm getting more into that in another video, but Dick is all tricks and attempts at intimidation. He comes ill-prepared with almost nothing in hand and relies on stunts, tantrums, and verbal attacks to fight his side. For the life of me, I do not understand how this man got to where he is today. Was he always like this, or is it just what he's become? I don't know, but this motion was It was hateful, middle school level aggression that distracted from any points he was making. Some of them were actually valid points, but the delivery is such a turnoff that you just want to reject them anyway. So we just dive straight into unfounded, presumptuous accusations, where he states, the state wants an extension from this court so that it can conduct its objective investigation, in quotes, indicating, sarcasm, free from oversight and deadlines set by a trial court while denying Mr. Murdaugh any ability to participate in the process. Did the state ask for an extension? Did the state ask for any of these things? Everything I've seen in court has been the state saying, we're ready, while defense throws tantrums and comes up with every manner of excuse to put things off.
What's the hurry? That's the other one. What is the hurry? He's pleading in federal court next Thursday. Every allegation the state has made, the victims will have their day in court. Mr. Murdaugh indicated he pleads guilty to the state charges, but the state insists on doing them in serial so they get 3 convictions so they can get life without parole on a guy who's already serving 2 life sentences without parole. I'm bewildered by this. Certainly they can do it, but why? Why? What is the hurry?
Why is the defense, who at Cory's hearing just last week express just how very pressed they are and how little time they have to dare to try to schedule anything until next fall. But here they are screaming, "Hurry up, let's do this." As Dick himself said, what's the hurry? Alex is in prison and about to be sentenced to more prison for his financial crimes. He's not getting out of prison. So what, in your own words, Dick Harpootlian, what's the hurry? Also, what is this accusation that they want to do this without oversight or deadlines? The state never said such a thing. They said they would be willing to concede to an evidentiary hearing which would be carefully presided over and all evidence tested out publicly in court. So what is this nonsense besides trying to victimize themselves based on imaginary threats? Then, the wild accusations that the state would be too embarrassed to directly ask an appellate court to retain jurisdiction over a factual dispute. Then it gets worse. Instead of remanding it to a trial court that can receive evidence based only on its desire to conduct unsupervised factual discovery. And then it goes on to state that the procedural requirement that Alex provide an affidavit that he was unaware of the jury tampering during the trial is not actually a requirement. Alex is a known liar. Dick and Jim have lied on his behalf. Whether they knew what he had supplied them with were lies or not, they have stated publicly and in court multiple times lies that they've been told by Alex. Excuse the state if they don't just want to take their words for things and want things specifically in affidavits. He then goes on an exhaustive ramble about the rule that he used to file this motion and why, but the state never questioned that. The state simply said they had missed some components in order to file their motion correctly, so he's fighting with himself here. He begins to demand a new trial again, quoting Holmes versus United States, saying, holding where there was the private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. A new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. But this argument could be used to say that this is exactly why an evidentiary hearing needs to be held. First, you have to find out, did this communication in fact exist? Because we have jurors ready to make sworn statements that it did not. It's very premature to just sit there and demand a whole new trial, a trial which took 6 weeks and how many hundreds of thousands of dollars to hold in the first place. Naturally, the next step, an evidentiary hearing, should not be skipped. It needs to be found out if there was this communication, and if communication was made, was it harmful or harmless? Could it have affected the verdict, or did it not affect the verdict? These are all things, by this very own citation he quotes from, that need to be resolved first. How do you jump straight to a new trial? At this point, he's expecting the court to accept an affidavit of a juror who was excused and had nothing to do with the verdict. A juror who we've now seen, in fact, was out there running her mouth. Fitz News posted the recording. I made a video of it too with clips from that recording. The person who sent the email to the court in the first place was someone who heard from the juror. She was out there running her mouth. If she wasn't, how did anyone know she was a juror in the first place during the trial? They're not supposed to tell people that, yet people knew. Quite a chain of people. This email was sent to the judge during trial. She obviously disclosed to people that she was a juror. She obviously disclosed to people how she felt about Alex's guilt. It's also a fact that Judge Newman held a hearing for this. There is a transcript of this meeting where before him and before the attorneys from both sides and any relevant court person, she denied it. It's in black and white in the transcripts. But she was rightly removed, so how is the court going to take anything that she said seriously? She had already betrayed her oath as a juror by out there talking about it. Then she lied before the court itself. So obviously any sworn statements or promises of truth from her are worthless. She has already lied to the court. Her affidavit should not even be admissible. Then what else do we have? We have 2 affidavits that were written and signed by Dick's paralegal, Holly Miller, one of which denies Becky had improper conversations when they asked him about it. Then there's 1 affidavit by an actual juror, but already we have 4 jurors who have retained attorney Eric Bland and have stated that Becky did not have these conversations. And we have no idea how many of them have spoken to Creighton Waters and given statements to him. How is Dick going to demand a new trial based on what he's holding now? An evidentiary hearing is the logical next step, no matter how hard he stomps his feet and screams in court. And the state has not expressed embarrassment or stalled. They have already said that they concede that this hearing may have to take place. He moves on to insulting the state for citing cases from the 19th century. Sir, the U.S. operates around a constitution that was written in 1787 in the 18th century. So what exactly is your point with that? He next moves on to attack the state's claim that an affidavit from the defendant stating that he did not know of this tampering during the trial is required in order to proceed. He goes on to explain how the case cited, State v. DeAngelis, differed from this one, and I concede that this is one of their valid points. It says, it is the fixed rule that the credibility of newly discovered evidence offered in support of a motion for a new trial is a matter for determination by the circuit judge to whom it is offered. In him, not this appellate court, resides the power to weigh such evidence. In him, not to this appellate court. And then just after that, he says, but the state would be too embarrassed to directly ask an appellate court to retain jurisdiction over a factual dispute, instead of remanding it to a trial court that can receive evidence based only on its desire to conduct unsupervised factual discovery. Which court is he wanting to present it to, because he changes direction in the same document? He then attacks the fact that the state wanted to know when and how this evidence was discovered, and says the when is the dates on the affidavits. But this is in direct contrast to statements that he made in press conferences and on TV appearances that he saw something during the trial that was questionable. The affidavits were signed sometime after that and after conversations had with these people. So the question of when this information was first learned is still not answered. He then makes accusations that this is all for purposes of delay. Again, what's the rush? Dick made it very clear in court he has no time at any point in the near future for cases that have been on the table since late 2021, but suddenly wants to accuse the state of delaying something that was brought to their attention on the 5th of this month that they had only until the 15th to respond to, which was 8 days ago. It's hardly the delay that he's making it out to be. He doesn't get to demand a new trial and throw fits because the court doesn't simply say, sure, how about tomorrow? There is a whole finding out if there's even any truth to this so-called proof. And if the rest of his year was so cram-packed as he made it out to be last week in Cory's hearing, what is he even on about here? In closing, he goes so far as to imply that sanctions might be needed. After all the dragging his feet he's done for other matters, he now wants to sanction other attorneys who found out about this less than 20 days ago. And then at the very end, he tells the court again that they should grant this motion for a new trial. Now, the court put out a reply the same day that I've seen a few people laughing about, saying that the court shut this document down. But I'm not sure if it was meant to be a reply to this document or if it was meant to be a reply to the document that was filed with the court on the 18th, which was supplemental information about that Facebook post. But either way, it's the second document filed on that day that the court had to let these attorneys know they had not filed correctly. But speaking of that Facebook post, I don't know why they're making such a big case about this. The egg juror was not excused over this. The court held a hearing. They determined it did not come from the ex-husband, and she remained a juror until it was discovered that she was out in the wild telling people she was a juror and giving her opinion on the guilt or innocence of Alex Murdaugh. But I guess we'll find out next week which filing it was a reply to. Back to our other news of the day, Cory Fleming, who hung his head in remorse as he voluntarily submitted a guilty plea, as it turns out, didn't much care for his sentence. I'm sure his victims didn't much care for what he did to them either, but he wasn't concerned about that, was he? So all that remorse that was on full display in court has now been taken back. He has appealed his sentence. But guess what? It was filed with deficiencies. The response from the court says, "Dear counsel, upon reviewing your notice of appeal, the following deficiency or deficiencies have been noted under the South Carolina Appellate Court rules, and any deficiency must be corrected within 10 days of the date of this letter, or this matter will be dismissed." The first deficiency, the notice of appeal is not accompanied by a redacted copy of the orders and/or judgments challenged on appeal. The second one, a proof of service has not been provided. You must serve and file a proof of service substantially in the format shown by Form 7 in Appendix C to Part 2 of the SCACR. Third deficiency, you must provide proof that the notice of appeal was filed with the trial court clerk of court. So because of these deficiencies, unfortunately, that's about all I can tell you at this point, since the attorneys for the attorney forgot to add the redacted copy of the order or the judgments that are being challenged. How do these people not know the proper way to file an appeal? There were two more surprises at the hearing and the press conference after. Those were that they asked Judge Gergel to sign an immediate forfeiture order for Alex's assets to be seized by the federal government.
What we did was simply ask for the order, for the preliminary order to issue immediately, to avoid the possibility of, or the almost certainty of dissipation of the assets and some of the civil proceedings that appear to be imminent.
That will stop all the bleeding, all the attorney's fees attached to those funds, and there will be more money for the victims. And that's all the money he has, and there is no other money. And right now, the burn rate on attorney's fees coming out of that money is
Hundreds of thousands of dollars.
Didn't you also request attorney's fees out of that money?
We did, but
They've attempted different ways to get more attorney's fees out of Alex's frozen assets and have been turned down every time. They were not concerned about Alex's victims if they could get their hands on the money. But since they can't, they don't seem to want anyone else to be able to either. Though they're framing it as an altruistic, it's for the victims manner, when we know that they're still fighting the Satterfield matter and have yet another appeal filed on their attempt to say Alex lied about the dogs so they should never have gotten the settlement, it makes it hard to believe it's for the victims. They're fighting tooth and nail against the victim he stole the most money from. That makes it very hard to believe, again, that they're doing this for the victims. And this is messy because Alex nor his attorneys are the holders of his assets. He has not had any access since his assets were frozen on November 2nd, 2021. They have long been in the court's hands. It was court-appointed lawyers that found and dealt with what he had left, which I made a video about that I'll link in comments. So, is the federal government going to forcibly take that money from the state? Also, according to the plea agreement, Alex has to testify and tell everything he knows about the crimes, which is expected to be a lengthy process. We don't even know when the federal court could even begin such a thing or how long it will take. The state has a trial scheduled for the Satterfields on November 27th. If it should happen first, then what? But we can bet all of this rush to plea on federal charges and to get the money to the federal government is another underhanded move to undermine state. As a state senator, this is despicable of Harpootlian. To do this to his own state because he lost in court. I feel he's determined to make this case a legacy case for himself and seems he'll stop at nothing to win. The other surprise was they said they're trying to stop the state trials from happening at all. They also would not comment on whether or not Alex would plead guilty to those charges, should the trial remain on the docket. So much for caring about the victims. This three-ring circus just keeps spinning, and I will keep on reporting. Until next time, this is Cassidy O'Connell, saying stay well and stay tuned.